A living trust is an essential estate planning tool that can help you manage your assets during your lifetime and ensure a smooth transfer of those assets to your beneficiaries after your death. Unlike a will, a living trust allows your estate to avoid California probate, offering privacy and potentially reducing the time and cost involved in settling your affairs. I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. And in this video, I'll share a step-by-step guide to help you understand how to create a living trust in California. Step 1. Understand what a living trust is. A living trust is a legal document that places your assets, such as real estate, bank accounts, investments, and personal property, into a trust for your benefit during your lifetime. Upon your death, the assets are transferred to your designated beneficiaries by a trustee without going through probate. Step 2. Decide between a revocable and irrevocable trust. Meet with an experienced estate planning attorney who can explain the types of trusts available and which one is best suited for your needs. Two of the main types of trusts are as follows. A revocable trust. You retain control over the assets in the trust and can amend or revoke the trust at any time. This is the most common type of living trust. An irrevocable trust. Once established, you cannot modify or terminate the trust. It can offer more substantial tax benefits and asset protection, but comes with a loss of control over the assets placed in the trust. Step 3. Identify your assets. Take an inventory of all your assets that you want to include in the trust. These might include real estate properties, bank accounts, stocks and bonds. Make sure that you gather all relevant documentation for each asset, such as deeds, account statements, and titles. Step 4. Choose your beneficiaries. Decide who will receive the assets in your trust after your death. Beneficiaries can include family members, friends, nonprofits, religious or educational institutions, or other entities. You can specify how and when each beneficiary will receive their inheritance. Step 5. Select a trustee. You can act as the initial trustee, allowing you to retain control over your assets while you're alive. Your will needs to appoint a successor trustee who will take over after your death or if you become incapacitated. Once the last settler passes away or becomes incapacitated, the successor trustee is responsible for managing the trust's assets and ensuring that they are distributed according to your wishes. Step 6. Draft the trust document. The next step is for your attorney to draft the trust document, which outlines the terms and conditions of the trust, including the name of the trust, the names of the trustees and successor trustees, a detailed list of the trust's assets, instructions for managing and distributing the assets, any special provisions or conditions. While it's possible to draft the trust document yourself using online templates, it's highly recommended that you work with an experienced estate planning attorney to ensure that the document complies with California law and accurately reflects your wishes. Step 7. Sign the trust document. Once the trust document is finalized, you'll need to sign it in the presence of a notary public. A notary public will ask for identification and witness you signing your documents. In California, this step is crucial to make the trust legally binding. Step 8. Transfer assets into the trust. For the trust to be effective, you must transfer ownership of your assets to the trust. This process is known as funding the trust. It involves retitling assets such as real estate, bank accounts, and investment accounts in your name as trustee of your trust. For some assets like personal property, you may simply list them in the trust document as being part of the trust. Step 9. Store the trust documents safely. Keep the trust documents in a secure location, such as a safe deposit box or a fireproof safe. Your estate planning attorney should also retain a copy of the documents in your estate planning file. Make sure your successor trustee knows your attorney's name, where to find the documents, and how to access them when necessary. Step 10. Review and update your trust periodically. Life circumstances change, and your trust should reflect those changes. Review your trust periodically, especially after major life events like marriage, divorce, the birth of a child, the death of a beneficiary, when minor children turn 18, or the acquisition of significant assets. If you have a revocable trust, you can ask your attorney to amend it as needed. If you're considering setting up a living trust, consult with an experienced California estate planning attorney to ensure that your trust is tailored to your specific needs and circumstances. By following these steps and seeking professional guidance, you can create a trust that provides peace of mind for you and your loved ones. If you have any questions about creating a California living trust, feel free to contact our law firm.